Hello, and thank you for joining us. My name is Katie Perez, and I am a senior associate at Scott Legal PC. Today, we are going to spend some time talking about the National Interest Waiver rules and requirements. As we will discuss today, the National Interest Waiver is an employment-based green card category that permits self-petitioning. It is also available to entrepreneurs in a wide range of endeavors. This webinar will go over what is needed to obtain a National Interest Waiver. Just a few things before we get started. Some of you may know that the firm was founded on an E2 visa several years ago. Our founder is in the US on an E2 visa and has been on several different visas, including an F1, ATN, B, and H1B. As such, we know what you're going through. Scott Legal is a full service immigration law firm, and we offer immigration services in several different areas, including E2, E1, TN, L1, family immigration, national interest waivers, EB5, extraordinary ability visas, and more. We will continue this webinar series doing at least 2 webinars a week on different topics. At the end of this webinar, we will send out several useful tools. We will send you a copy of the PowerPoint presentation from today, a link where you can download guides that go through the visa options in more detail, and also a link to where you can sign up for additional webinars. This webinar will be recorded and available on YouTube. We will also send the link for that. We encourage you to subscribe and hit the notification button as we regularly upload immigration videos on a wide variety of topics. We will also send you a link where you can arrange a consultation with one of our experienced immigration attorneys if you would like to discuss your case in more detail. If you have any questions throughout the presentation, please put them in the chat box and we will address them at the end of the presentation. Today, we are lucky to have Jiyae Hwang with us. Jiyae is a senior associate at Scott Legal and has a wealth of experience handling a variety of immigrant and non-immigrant visa petitions, including EB2 national interest waivers, EB1A extraordinary ability petitions, O1s, E2s, and TN visas. Without further delay, let us get started with the webinar. Jiyae?
All right. Thank you so much, Katie, for the introduction. So yeah, let us get started. Thanks everyone for joining us. So let's start with the overview of what is a national interest waiver. So basically, an NIW is short for a national interest waiver. And the NIW is a green card option that actually allows you to self-petition. So when we speak of waivers, it means that the government is waiving the normal requirement for an applicant to get a U.S. job offer and get a U.S. company to sponsor them. And importantly, usually when you're doing an employment-based green card, the government will require the U.S. petitioner to actually test the labor market, right? To see if there is any other person who is minimally qualified in the U.S. Who could, possibly take that job. And only if the U.S. company can show that there is no one else in the U.S. who can take that job, then usually the company is allowed to sponsor a foreign national for a green card. However, when we speak of waivers, right, in the national interest, this means in this particular case, the benefits of having this foreign national come in and do this important work, it's so great that the government is waiving that requirement for a U.S. job offer, for a U.S. company to test the labor market before, having somebody be, eligible for an employment-based green card. So basically, the EB2 NIW is a green card option that can be available to self-petitioners when the government concludes that this person is coming to the United States to do something that is in the national interest. So because of this is pretty much a privilege, right? And so there is really a burden of persuasion, right? When you are, planning to apply for a green card under this EB2 NIW channel, you do need to persuade the government that you're doing that something special, right? And we will talk a little bit more in detail about what that means, to have something be in the national interest, because it is a very technical term and it can be very subjective in interpretation, but that is the general gist of the EB2 NIW pathway. So NIW is a subset of the EB2 employment-based green card category, but has a much higher bar than the perm-based company sponsorship because it is basically a waiver, right, of the normal requirements of a labor certification. And it does give a lot of advantage, right, to especially to petitioners who may be entrepreneurs who may not have a U.S. company that is willing and able to sponsor, the person. So the EB-2NIW can provide a great advantage for that because it allows self-petitioning. The EB-2NIW also gives the advantage of a faster processing time if you look at the entire green card timeline, because you are exempt from going through the ordinary perm process, the labor certification process, which not only is burdensome, but also can be very time consuming. So the perm processing can take, many months, even years, for the U.S. employer to get the result, to be able to petition for the green card. So the EB-2NIW can provide a little bit of a shorter pathway, a faster track pathway to a green card. Instead of going through perm. But that means there is a higher bar to qualify for that particular benefit, right? Because it is not a benefit that is given to all cases in all applicants. So, what are the requirements to qualify for an NIW? So the NIW has a 3 requirement test that is based on a recent case from 2016. It is called Matter of Dhanasar. And in addition to meeting the 3-prong test of Matter of Dhanasar, which basically defines what it means for a case to be in the national interest, right? You must also show that you do meet the underlying EB2 threshold that is applicable to both perm cases and to NIW cases. And the EB2 threshold basically is to show that you either have an advanced degree, which is defined as a master's degree or higher. And you can also meet that by showing a bachelor's degree in your field and 5 or more years of progressive work experience in your field, or show that you have exceptional ability in your area of endeavor. And we will also go a little bit in more detail about that in the next following slides about the EB2 threshold. So as I mentioned before, in the first bullet, you do not need a sponsor to apply for national interest waiver. So the national interest waiver is definitely a privilege that you get from the requirement to have a U.S. job offer and a sponsor in the United States. So you can apply as a self-petitioner. It is definitely an option. And the waiver relates to the EB2 requirement to prove that the employer cannot find a qualified U.S. worker. And the challenge for the NIW is proving why your case meets an exemption from the ordinary requirements of a job offer in the national interest. And finally, the one thing that we want to emphasize here is that there is no limitation on the type of field for meriting a national interest waiver. You can technically apply for an NIW even if you're in any field, in the humanities, philosophy, law. There is really no limitation in the field. What you're doing with your specific proposed endeavor is what's important, not the nature of the field. So, for example, if you're, somebody who's a leading researcher in English literature, and you're providing, a very strong contribution to the field by providing a new methodology or theory on how to, analyze English literature. And if you, can prove that you've had that kind of influence and you will continuing to be having that kind of influence in your field, then yeah, that can also be a basis for a green card under the EB-2NIW category. So there is really no limitation on the type of field, and it is definitely also not just limited to STEM fields, although STEM applicants may get a bit of an advantage in certain contexts. It is definitely not a category that is only limited to STEM. All right, so now let's talk a little bit more detail about the threshold requirement to qualify for the EB2 category as a whole. And when I speak of threshold requirement, this is a threshold requirement for the EB2 category that applies to either perm or NIW cases. So definitely it is important to make sure that you meet the threshold requirement even before you start looking at the national importance factors. So the way to meet the EB2 threshold requirement is either by showing that you have an advanced degree, which is defined as a master's degree or higher, So, for example, a PhD degree, you would qualify with that. And even degrees such as a JD or an MD, right? A medical doctor or a Juris Doctor. Those types of degrees also are seen as an advanced degree. And the reason why is because you typically need a bachelor's degree to gain admission to those kinds of programs. So it is a higher level than a bachelor's degree. So if you have a JD, then that will, or an MD, that will count as an advanced degree. MBA, right? Masters in business administration, things like that would definitely also count as an advanced degree on its own. One thing to note is that if you did not earn your degree from a US institution, then you would also need a US education equivalency report from, an agency that provides such credential evaluations. And the reason why is because you need to prove that the particular foreign degree that you have is actually equivalent to a master's degree, or, the particular level of degree that you're trying to prove in the US context. So you definitely need that evaluation if you are trying to qualify with a degree from any other country than the United States. Um, Another way to show that you are, the equivalent of an advanced degree individual is by showing that you have a bachelor's degree in your field and also showing that you have at least 5 years of full-time post-baccalaureate work experience that is progressive in your field. And let's break that down a little bit on what that means. So when we speak of progressive work experience, the government wants to see proof that not only have you been working for full time for 5 years, but the job duties that you have been engaged with change over time to increase in complexity, increase in seniority, increase in responsibilities that you take on, such that your job trajectory can be seen as progressive. So basically increasing over time, right? So you can also, describe any changes in your title. So if you started off as a junior engineer and then you're a senior engineer and then, a principal engineer, that those kinds of changes could show that there has been that upward progression of the job duties. Similarly, if the types of projects that you've been, engaged in have been increasing in complexity and scope over time, you would definitely want to emphasize that to show that progression. If you have had any increases in salary, maybe you can talk about that. So when you're trying to meet the threshold with a bachelor's degree plus 5 years of progressive work experience, you do need detailed letters that confirm your work experience from your previous employers, and you want those letters to come directly from the previous employers on employer letterhead to support the progressive work experience, and they should be in enough detail to show what your job duties were and how they changed. So make sure to uh, do that when you're preparing your file. Um, One thing to note is that the degree, the work experience must all relate closely to your proposed endeavor. So, for example, if you have an engineering degree and if you have an engineering work experience, then it makes sense that the proposed endeavor is also somehow related to engineering. However, if you have an engineering degree, you have engineering work experience, and then your proposed endeavor is to run a bakery. Now, USCIS has expressed that they're not going to accept that, right? Because the degree and the work experience is simply not related to the proposed endeavor. So when the USCIS is looking at your case, they will also want to see a close relation between the degree, the work experience, and the proposed endeavor. So that is definitely something you want to be careful about. Now, if you don't have a degree, if you don't have a bachelor's, if you don't have the work experience, another way to meet the EB2 threshold is by showing that you have exceptional ability in the sciences, arts, or business. And you can do that by showing at least 3 out of the 7 enumerated evidentiary criteria here. Um, And one thing to note is that exceptional ability is a lot lower standard than extraordinary ability that we speak about in the EB1A or O1 context. And the universe of evidence taken as a totality must show that you're someone who is operating at a level that is significantly above what is ordinarily encountered in the field. So when you're trying to prove exceptional ability, you do not need to prove that you're one of the very, very small 1% of your field, but you do need to prove that you're someone who is at a significantly higher level than what is ordinarily encountered. So it is a little bit of a lower standard to meet, but yes, that is definitely another channel you can use if you don't have that required degree to meet the EB2 threshold. All right, so now that we went over the threshold requirement, let's talk a little bit about the DANSR requirements. So the DANSR test is the three-prong test that the government uses when they are looking at NIW cases to, determine whether the case merits an NIW, right? Because the NIW, as I mentioned before, is a waiver. It is an exemption from the ordinary requirements of a job offer and a labor certification. So you do need to prove that your case is, something more than the ordinary case in order to merit the NIW. So let's go through the three prongs in a little bit more detail. So the first prong of the matter of DANSR test is that the applicant's proposed endeavor must have substantial merit and national importance. And the first step, and I would say one of the most important steps in the NIW preparation process, is to clearly define the endeavor. And the USCIS has been, looking at this with more and more scrutiny, right? So in the new policy manuals that USCIS published earlier in January 2025, we see that the government is looking for a proposed endeavor that is more specific than simply presenting that you will be working in one occupation. So, for example, if you are a pilot and if you present a proposed endeavor and say, my plan is to, get a job as a pilot, or my plan is to, work as a commercial pilot in the United States, that one sentence plan in itself would definitely not be specific enough to qualify as a proposed endeavor by USCIS standards. By contrast, USCIS would be looking for something more specific within that occupation. For example, like I am, you know, um, a pilot instructor, and I am planning to develop, this new educational curriculum with this new technology that would increase the efficiency of pilot training in partnership with University A or in partnership with, company A or something like that. That is a more specific plan, and that is closer to what the government will typically be looking for when they look at an NIW case, right? So you need to be very specific on the proposal, right, that you give to the government, even if you're an entrepreneur, right? Simply saying that I'm going to run a business in the United States, that will not suffice, right? Because that is simply saying that you're going to be working in an occupation. Similarly, if you're an engineer, you cannot just say, "Oh, I'm coming to the U.S. to, get a job as an engineer." You need to do more than that. So if you're an engineer, you want to talk about exactly what you will be doing in what kind of position, right? If you're doing research and R&D in your field, if you're researching a particular application of AI technology in, I don't know, self-driving situations. You want to really, flesh that out, right? And provide enough detail about the particular work that you'll be doing that is more than simply just working in an occupation. So that, I think, is an important challenge for all NIW applicants to ensure that they, put their strong foot forward for approvable NIW case. Now, another thing to note here is geographic scope of your work is no longer the focus per matter of DANSR, which is actually a very positive development, right? Because before matter of DANSR, the prevailing standard was to look at the geographic scope of the work that the person will be doing and whether that work would be quote unquote national in scope. But with matter of DANSR, the new case law qualifies that and says that even localized endeavors can have a nationally important if effect if it has, a broad impact on advancing the industry or field more broadly. So endeavors that have national or global implications within a particular field, such as improved manufacturing processes or medical advances, right, may have national importance regardless of the geographic scope of that particular endeavor. So you definitely want to make sure that you're making that qualitative um, argument about the impact of your work in your industry or field. So, similarly to what we've been discussing, the benefit must go beyond one's immediate employer or clients, and the government is looking for a broader impact to the field. And this relates a lot to engineer petitions, right? So, if an engineer petition is prepared in a way that talks about the engineer's benefit to only the employer that employs the individual, then that may not be enough of an impact to the field to qualify for an NIW, right? The government may say, well, if the employer is the only one who is benefiting from, the engineer's work, then you should just go through the normal perm process and have the U.S. company just sponsor the engineer, and have them test the labor market. Because if all they're doing is just doing what an engineer usually does to, benefit the private profits of a company, then that's what they should be doing. By contrast, if a particular work that the engineer is doing is going to result in advancements to the field as a whole, right? If the engineer is working on a very particular, cutting edge R&D project in a very, important, sector, I don't know, like aviation, right? And if they're looking at, if they're developing a very, cutting edge product that if it is, commercialized, it will result in many, follow on, efforts in the industry, kind of, providing a role model for the industry. If it's that kind of innovative product that they're working on, maybe there is, an argument that the impact will not only provide private benefits to the employer, but also will, benefit the field more broadly. And if we have that kind of argument, then we have a stronger case for, meeting the national importance criterion. Now, let's talk a little bit about substantial merit versus national importance. Substantial merit is the easier standard, but the case must meet both substantial merit and national importance. And usually, national importance is more difficult because when the government is looking at national importance, they focus on the larger scale and broader impact of the endeavor. And for substantial merit, anything that has some sort of benefit to society or, the economy can be seen as having substantial merit, but meeting the national importance standard is usually what becomes the challenge lately for many cases. So just two more examples to go through in clarifying national importance. The argument that the US has a job shortage in a particular area, such as, in the case of pilots, that unfortunately will not suffice as a persuasive argument for national importance. And there is a lot of AAO case law that confirms this, especially also in the particular context of pilots, because for a while there has been, some misinformation in the internet saying that if you're a pilot, you can qualify for a green card under the EB-2NIW because there is a shortage of pilots in the United States. But however, that argument is not true, right? And the USCIS has expressly qualified this, saying that job shortage alone cannot, be the sufficient basis for finding national importance. Because, and the reasoning is because addressing job shortage is done by the ordinary labor certification program, right? So the ordinary avenue of sponsoring a foreign national through perm, that's what Congress intended to serve as the major channel to address job shortage issues in a particular field. So that in itself will definitely not be a valid basis for finding national importance. In addition, another type of case that can have difficulty in the NIW context is if the benefits of a particular work tends to only benefit the immediate clients or recipients of that service. So, for example, teachers. Teachers is one example where the government has discussed that the benefits do not rise to the level of national importance. And their reasoning is that when you're a teacher and you teach, students a particular skill or knowledge that is already out there, only the students themselves are benefiting from that particular service, right? And the USCIS understands this to be a localized impact, not, the type of broad impact to the field or society as a whole that they're looking for in the national importance context. So when you are framing your proposed endeavor, right? So if you are a professor, for example, and if you are doing both teaching and research activities, maybe the teaching part of the proposed endeavor is, a less of a strong angle for national importance than would be the research, aspect of the work, because for the research aspect, you may be better suited to make the argument that your work will benefit on advancing the field more broadly by, improving scientific knowledge. Whereas if you're just focusing on your teaching, then you're vulnerable to the critique that your activities only benefit your immediate students, which USCIS has clarified is a localized benefit that do not rise to the level of national importance. All right, so now let's move on to prong 2 of the matter of Danaher test, which is that the applicant must show that they are well positioned to advance the proposed endeavor. And here the focus is on the individual as opposed to the endeavor itself, as it was in prong 1. So the government will look at an individual's background, such as their experience in education. The government will also look at whether the individual can show that they had a track record of success or influence in the field that will support the claim that their future work will be just as influential. So, in the case of scientists or people who are doing R&D, if the person has published intellectual property before, such as patents or uh, research articles that were published in academic journals, those types of work product can be very helpful in showing this track record of success and influence in the field, showing that this person really has a record of advancing, the envelope for the field or the industry. How far along is the proposed endeavor? That is another question that can be relevant for well positioned, especially if it is an entrepreneur petition. And we do a lot of work with those. If the entrepreneur is already in the process of, having developed the business idea, maybe they already have an E2 visa and they are already far along in their endeavor and it has been developing and growing. That can be helpful in showing this history of growth that can support future growth projections if economic impact is one of the arguments that is supporting national importance. Similarly, if the entrepreneurial project has received traction from relevant US institutions, maybe government institutions provided grants to a particular project, recognizing its potential, that can be very helpful. If the business project has been admitted to very prestigious accelerators or incubators like Y Combinator, Techstars, that can also be a very positive factor for well positioned because the individual can show that they were the one who developed the idea to that kind of stage in progression, and earning that sort of traction. Similarly, contracts can also help if those are contracts with, major actors, major players in the industry. You can show that, this idea has already been developed to such an extent where you already have contracts expressing interest. That can definitely be helpful towards meeting well positioned. Similarly, if the business has already been running, tax returns can be a helpful marker of business viability and progress. Forms W-2, for example, if your business has already hired U.S. employees, that can support, future projections that your business will continue to hire and generate U.S. jobs, which can be a positive factor for the NIW. So those kinds of business-related documentation can also be very helpful. The third prong now is showing that on balance, the whole petition as a whole should show on balance that it would be beneficial to the United States to waive the requirements of a job offer and thus a labor certification to this particular case because of the outsized benefits and the impact that we can expect to see in the field because of this particular case. So the way to meet prong three, you can, pick and choose from, any of the evidences that you used to support prong one and prong two. There is really a logical connection there. If you can show that you have extraordinary ability in your field, such as, being invited to speak at presentations or, being invited to serve as a judge of the work of others and otherwise have influence in your industry, all of those types of positive facts about you can be used to show that you're someone who has this unique offering that can really help the field, advance, and which really distinguishes you from, just another U.S. worker with minimum credentials that can fill your job. Another thing that entrepreneurs can use to their benefit is that the fact that entrepreneurs are usually self-employed and often they're not eligible for a green card under the labor certification program. So practically, that practical difficulty can also serve as a positive factor for this balancing test. Such that it would be beneficial to give the entrepreneur this chance to come into the United States and create, additional U.S. jobs, compared to the ordinary benefits of the perm labor certification, which is to save one more job spot for one more U.S. worker. So the broader benefit that you can prove that's related to your particular project, the more stronger the case will be for this balancing test. Final note with regards to the matter of the NSR case is that matter of NSR specifically notes that entrepreneurial work can lead to an NIW and even states that the planned venture does not need to ultimately succeed as long as the applicant can show that there is a plausible basis for that particular project and ensure that, all three matter of NSR prongs are met, including national importance, well position, and on balance, the benefit to the U.S. as a whole. All right, so just a little bit more detail on national importance because that tends to be the most scrutinized prong within the matter of NSR test. You do need to prove the importance of your particular specific proposed endeavor, not the importance of the field or occupation the individual will be working in. And that is kind of a pitfall that I see a lot in, many, self-filed petitions or, petitions filed by different, law firms that may not be as familiar with the nuances of the NIW. If you talk on and on about, the importance of AI to the US, you say on and on about the importance of aviation to the US, but you don't get into the specific project. And if you don't get into the impact of the specific project to the field, then the NIW argument is going to fail because the USCIS is not looking for evidence regarding the importance of the field itself, but on the applicant's specific proposed endeavor. That is a very targeted question that they are asking. Expert letters can be very important in building this narrative because experts in the industry can talk about what is the limitation in the industry and what is the applicant's specific project about and how will it solve this industry-wide problem. So the expert letters can really provide that narrative that is tailored to the applicant's specific proposed endeavor and can fill the gap, with regards to supporting evidence of the, importance of the proposed endeavor. So that can be a very important strategic point on how to prepare the expert letters and what are the expert letters going to say. As we spoke about in previous slides, benefits to one specific employer alone will usually not be enough to meet the national importance standard. And the government is really looking for sufficient evidence, talking about broader impacts to a field or region or public at large. So these are the examples that the government uses in the USCIS policy manual. For example, a person developing a drug for a pharmaceutical company may establish national importance by demonstrating the prospective public health benefits of the drug instead of solely projecting the profits that will accrue to the employer. Also, if you can show there is widespread interest in the industry in adopting or licensing a technology, if you can show that you will be developing a novel and important manufacturing process that will have a large scale impact, or how this technology tends to impact the development of similar technology at other companies, those are all examples of a broader impact that goes beyond the private benefits of one particular company. So when you're building your NIW argument, it is very important to make sure that you go there and go beyond just projecting benefits to one particular company. Substantial economic benefit, creation of US jobs at a level significant with respect to a population or economy of a region. So it is also possible to use job creation as a basis for an NIW to meet national importance, to meet the national importance standard. But if you're just relying on job creation, the number of job creation must be significant. So we're not talking about 10 jobs, 20 jobs. We're talking about hundreds of jobs that will make a significant impact to a particular region of an industry, like large scale economic development projects, creation of jobs at a large scale. That can also, support national importance, but keep in mind that the level must be very significant in order to support that. All right, so let's talk a little bit more about the nitty-gritty details of what is typically included in an NIW submission. What does it look like? What kind of supporting documents are, accompanying a successful NIW petition? So the first thing you want to make sure is to include proof that you meet one of the threshold requirements. So either through an advanced degree or through showing that you have an exceptional ability in your field to meet the EB2 threshold. So if you are meeting the advanced degree threshold, you want to show the copy of the degree, like a diploma, right? And transcript to show that what the degree was about. If it is a foreign degree from a non-US institution, you want to make sure that you have a US degree equivalency report from a degree evaluation agency that shows that that particular level degree is equivalent to, the required level in the US system. And similarly, if you're qualifying with a bachelor's degree plus 5 years of progressive work experience, you also need to provide a copy of the bachelor's degree, transcripts and whatnot to show what the degree was about. And also, if the bachelor's degree was a foreign degree, you want to make sure that you also attach the US degree equivalency report to show that that foreign degree is indeed equivalent to a US bachelor's degree. And this is a very important requirement to keep in mind, because for some foreign degrees, the equivalency may not be as standard. So you do need to make sure to do this work in advance to just make sure that there won't be any problems with qualifying for the threshold. It would be very unfortunate if you meet all the other requirements, but if you fail the threshold, then it's a still failed NIW petition. So you want to ensure to avoid that situation. If you're meeting the threshold by showing exceptional ability, you do need to show, you would include documentation proving at least 3 out of the 7 criteria that we went over in the previous slide, and make sure that there is a substantial volume of evidence to, in its totality, it must tend to show that you're someone who is operating at a level that is significantly above what is ordinarily encountered in the field. The other part of an NIW petition, and this can, involve, hundreds of pages of material, is a volume of evidence showing that you meet all 3 matter of Danaher criteria for national interest, and we want to make sure that there is sufficient material to support both national importance, well positioned, and on balance, it will benefit the United States to exempt the labor certification requirement for you. And so, what kinds of evidences are usually used for supporting the matter of DNSR factors? Let's take a look. News articles, academic papers, market research that can be helpful in showing what the challenges in your field is. But also, those types of third-party articles must be combined with material that is very specific to your project. So, if you're an entrepreneur, for example, you definitely want to include a comprehensive business plan that goes over what your business is doing, what kind of industry-wide challenge you are addressing, and what are you, trying to provide, to the field, and what your economic impact will be to, in terms of economic production, right? So if you're going to hire US workers, you want to talk about that. If you're going to, you know, generate revenues and tax revenues, you want to make sure to quantify those prospective benefits for the officer to see. So a comprehensive business plan will definitely be a very important part of an entrepreneur NIW petition. Government reports and other objective evidence can help in corroborating some of the claims that you're making about why your project has such a, huge impact, will have such a huge impact to the field in, or to the public, right? So to support the scale of your prospective benefits, you would want to make sure that you have enough corroborating evidence because the government won't just take your word, right? Basically, you want to, make sure that every single claim that you make is, somewhere supported somewhere by objective evidence. So this can definitely be a challenging endeavor. Expert letters can be used to back up this claim of influence or this claim of prospective impact, right? So experts in the field can identify what are the pain points in this particular field. Like if you're in the medical field and if you're developing a drug, what is the challenge that pre-existing drugs are having, and what is, the benefit that will come to the industry as a whole by your work in developing this new drug, right? So the expert letters narratives must be very tailored to your particular proposed endeavor. And this is a limitation that I see in, in many cases, that if expert letters are too vague or broad or use conclusory language, for example, if an expert letter just says, "Oh, this person, will this project will definitely have, a national impact," and then just stops there, the government is actually not going to rely on that, and they're not going to look at that as a probative piece of evidence because it's just repeating the regulatory criteria, right? So you do need to make sure that the expert letters are going into enough detail and concrete, explanation that shows why this particular project will have a national, nationally important impact. To successfully be taken as a probative piece of evidence by the USCIS. So the way that the expert letters are prepared and what the expert letters focus on can be a very important strategic point. Applicants' resume, degrees, proof of professional accomplishments such as awards, patents, presentations at conferences, industry or media recognition can be very helpful, either towards showing, the prospective impact of somebody's work, or proving that this person is well positioned to drive forward this endeavor. Evidence of a past history of success in a relevant field is particularly important, uh, especially to meet the well-positioned prong. Entrepreneurs may also include proof of contracts, letters of intent, and startup capital to show that the endeavor has received that traction from the industry and the market and is likely to succeed. And any other evidence that tends to, confirm, an outsized impact, and unique offering that this particular project makes to the field can be helpful. You can reiterate evidence that you use for prong 1 and 2. You can, use some of the extraordinary ability related, evidence such as, being invited to serve as a judge of work of others. Those things can also be helpful. Membership in prestigious associations can also be used to show influence. So you can be very creative on what kind of evidences you use to build, a persuasive case. And many NIW petitions that we work on tend to be very tailored to each individual. We don't really do a cookie cutter type of petition because every single applicant has different strengths and weaknesses. And what we do is we try to put the strengths to the forefront to, really help with meeting the dinosaur test. So really having a skilled lawyer help you navigate this process can be helpful for you. All right, so now let's talk a little bit about recent trends and strategies for the EB2 NIW. The first point to make is that NIW has seen a significant increase in filings over the past 5 or 6 years. As a point of reference, in 2018, the total number of EB2 NIW cases filed per year was only around 8,000 cases, but now in 2025, we're seeing a trend of almost about to reach 70,000 for the entire year now. We've for the data for the first 2 quarters of 2025, we've already exceeded 37,000 cases that were filed for EB2 NIW. So the increase is definitely very steep. And what that means, there are many consequences of this explosive increase in filings, and one of the consequences is that the priority date backlog is getting longer and longer. And what that means is before 2022, the category for EB2, the prior dates for EB2 used to be current, which means as soon as you get the approval for the NIW, you can also, move forward with the green card application. But that's no longer the case, right? There is almost a 2-year delay in the priority date, backlog in the EB2, category as a whole. So now we're seeing, people who were approved for their NIW in 2023, like they're now, moving forward with the second step for applying for the green card, either by, filing an I-485 or by filing for an immigrant visa. So this whole, green card processing, through NIW has increased significantly in terms of how long it takes. But the other side of that coin is that RFEs and denial rates have also increased. And I do think that this is related to the explosive increase in volume, is that USCIS is, putting a lot more scrutiny on, things like, has this applicant proven national importance, in the right way, right? How can the applicant, show that this work will have a broader impact to the industry instead of just, resulting in private profit for one employer, right? So now we're seeing much more scrutiny on, all aspects of the NIW criteria, the matter of dinosaur test, and much, more frequent RFE rates. So that means that, the channel to qualify for the green card under EB2 NIW has become more and more difficult. The other thing to note is that the government recently issued policy guidance that clarified several NIW aspects, including how the government will interpret national importance, and we've went over a lot of those in the previous slides, and those changes came about in January 2025, and we don't know how this will change going forward with the new administration, but that is definitely something to keep an eye on. Because national importance can really change over time, depending on the priorities of the administration. So definitely, we are keeping an eye on any developments there. Entrepreneur-specific strategies. So let's go over some entrepreneur-specific approaches. One of the ways that entrepreneurs can support substantial merit and national importance can be the following. So if you can show significant media attention on your business or yourself or both, that can usually be helpful. If you receive awards or grants from government entities, that can also help meet the national importance standard. Letters from third-party industry actors, such as major venture capital institutions, can also be helpful. So definitely, you can take a look at the enumerated examples. Those are not the typical types of evidences that a PhD graduate would use if it is a researcher-based petition. But we have seen significant success in working with entrepreneurs who can nevertheless show the impact of their work using, non-traditional types of evidence. Similarly, well-positioned can be supported by, information such as ownership and critical role in the U.S. startup. Any degree certifications or letters describing, outstanding entrepreneurial experience, evidence of investment interest, especially from, recognized institutional investors or third-party investment firms, incubator and accelerator participation, showing traction in that particular business idea. All of those are things can be helpful in meeting the well-positioned prong. So entrepreneurs can definitely be creative on what kinds of evidence they would present to present the merits of their case to meet the three-prong criteria. All right, so now let's shift gears a little bit and talk about timing and other logistical considerations when you are considering moving from a visa, a non-immigrant visa, to a green card under the EB2 NIW channel. So, timing. Let's talk about timing. Premium processing is available for the underlying I-140, which is the petition for eligibility for a green card under the EB2 NIW criteria. An action will be rendered in 45 business days now. So this can be an approval. It can also be a request for evidence. It can also be, more rarely, a notice of intent to deny. The government, will commit to providing some response within 45 business days. And that's if you use premium processing. Regular processing is also an option. And that means the I-140, which is the underlying NIW petition, will be pending for approximately a year. So depending on your priorities, you can either use premium or regular processing. Now, one thing to note is that getting the approval on the I-140 is not the end of the green card process. So the green card really has two steps to it, right? So the first step is getting the approval on the I-140. The second step is filing the actual green card petition, the I-485, which is an adjustment of status petition if you're already in the United States on a different non-immigrant status. Or if you're outside the United States, you can also use consular processing for an immigrant visa, which means you will file a DS-260 with your home country consulate, and you will go to your home country consulate to attend the green card interview and get a immigrant visa stamp in your passport. And then you can enter the United States after that as a permanent resident. And if you're already in the United States on a non-immigrant status, you can choose whether to, do an I-485 within the US or use consular processing. And there are pros and cons for both. If you're outside the United States, consular processing is the only option for this step two of the process. One thing to note is that currently there is a backlog of priority dates, which means there can be a delay between the completion of step one of the process, the approval of your green card petition, the I-140, and moving on to step two, the actual green card application. Right now, as of the date of speaking, the delay is around 2 years. So we're seeing like people who filed their NIWs in 2023, they're, filing for their I-485 now. So that is definitely something to keep in mind. The priority date backlog can't really be predicted, but it's really a function of there being more people being approved for the EB2 green card category than there are green cards available in any given year. So there is a quota, there is an annual quota on how many green cards are available in EB1, EB2, and other categories. Right now, the situation is just that there are more people that are approved and qualified for this category, then there are visas available, which is why there is this backlog. And it is kind of a first come, first serve kind of system. So once you file the EB2 NIW, you will get your priority date. And only when, your priority date is current with that particular month's visa bulletin, then you can move forward with step 2 of the process. This is very complicated, so please feel free to reach out for a consultation if you'd, like more explanation on this priority date issue. Underlying visa status. So there are some underlying visa statuses that are very strictly scrutinized in terms of non-immigrant intent, and those visas include things like a B1, B2 visa, or an F1 visa, or a TN visa. And even the E2 visa is not dual intent, which means you always need to show that you have non-immigrant intent to qualify or renew such a visa. And filing an I-140, which is filing the NIW application, right, can be taken as a sign that you have immigrant intent, which may complicate this inquiry, right? So timing may be important on when you need to renew a non-immigrant visa, for example. Maybe it's better to renew that non-immigrant visa first and then take some time and then, take action to apply for the NIW for a green card. To avoid there being any complications with renewal. Definitely a complicated issue. There may be different factors in play, so talk to your lawyer before making a decision there. Application process, I did talk a little bit about this, but it is basically a 2-step process where you file the I-140, get that approved, and then wait until your priority date is current, and then you go forward with the second step, which is actually filing for the green card through either filing an I-485 or doing consular processing. The advantage of filing an I-485 in the United States, if you're already there, is that you're allowed to continue staying in the United States while the I-485 is pending. But the downside to that is that if you're in I-485 pending status, you can't leave the country, you can't leave the United States before, there is a decision on the I-485, or you can also apply for what is called the advanced parole, which is, authorization to, travel and come back into the United States. And you can come back in and be paroled in with that if you have the advanced parole. But outside of that, if you travel while the I-485 is pending, that will mean you abandon, your application. So that means you can be stuck in the United States for some time if you file the I-485. You can also choose to consular process the green card application, which means you're, applying for an immigrant visa through abroad, through a U.S. consulate abroad. And the advantage of that is that you can, continue traveling in and out of the United States because you're processing this abroad. The disadvantage would be that you will need another basis to, continue living and working in the United States. So definitely speak to your lawyer because there are 2 different channels and they have different risks and advantages. All right, so now we have a case study of a successful NIW case filed on behalf of an entrepreneur. Now, since we're running out of time, I don't think I'm going to read through this case study, but we are going to send you the copy of the PowerPoint so you can take the time to read through this case study, which can be very informative. So yeah, now I think we will go through the Q&A and see if there has been any questions. How long should my proposed endeavor be? 30 pages, 100 pages. So usually when we prepare petitions, the proposed endeavor definitely does not tend to be 30 or 100 pages long. We would usually try to make it more concise and shorter than that. But really it depends on, the case, right? Because maybe if you're talking about a business plan, maybe the business plan is more detailed, so it can go, up to 30 pages. So definitely there is no hard and fast rule on how long a proposed endeavor statement should be. But yeah, get in touch with us if you'd like to discuss your case in more detail. Does somebody need to wait until after graduation to meet the U.S. advanced degree requirement if you are still in a PhD program? So, to meet the US advanced degree requirement, if you already have a master's degree as part of your PhD, you can use your master's degree to meet the advanced degree requirement. So, you do not need to wait until the PhD itself, but you do need to have some sort of advanced degree completed. And if you already have the master's diploma, the master's, transcript that shows that you already have the master's completed, then you can use that. So you can use whatever degree is complete at the time of filing. It doesn't need to be a PhD because you can also use a master's. But whatever degree that you use, you must already have obtained that degree before you apply. Okay, the last question. When can you expect your priority date to become current? Now, we unfortunately cannot predict this question. The priority dates have been backlogged since 2022, and the priority dates, the threshold priority dates differ on your country of chargeability. So definitely get in touch with us with the consultation if you would like to discuss your case in personal detail. And definitely, if you would like to have us, do an evaluation of the likelihood of your case, we would need to, actually be engaged with the retainer to, provide more insight on that because the NIW is a very fact-specific category. So we do need to be familiar with all of the relevant facts before, making an assessment, and not no two cases are the same. And contrary to what you may find online, the NIW is a very complex category. It is not just about ticking some boxes. So yeah, we're always very we welcome questions. We welcome consultations. Please feel free to reach out to us if you'd like to speak to any of our experienced lawyers in more detail about your case. Yeah, and thank you so much for your participation.